Part 3 on the differences between mediation, arbitration, and court and family law. This is going to cover going to court. When you go to court, it means the parties have not been able to reach a full agreement and need to put some or all of the issues in front of the judge for the judge to decide. This also means that the parties did not agree to go to arbitration and are using the judge instead. Court is also an extremely inefficient process, and that means it is very expensive to go to court. The reason for this inefficiency is there are not enough judges, and each judge has way too many cases. One example that's very common is you might show up to court for your hearing. There are many other cases on the calendar. You sit around for several hours for your case to be called, and then the judge says, you know what, I don't have time to hear you today. I'm going to continue you to another date. And you spent thousands of dollars to have your lawyer travel to the courthouse, sit around, and get nothing accomplished. Then that new date may be months in the future. You also have absolutely no control over the judge that's going to hear your case. Cases are randomly assigned, and parties have absolutely no say in that process. Sometimes this is a good thing, depending on the facts of your case, but other times it's not. Because of the expensive litigation, I tell clients you need to do a cost-benefit analysis and decide if it's really worth spending this much money to litigate this issue. When it makes sense is typically in a custody situation where you have to protect your child and the other side won't agree to appropriate protective measures. Or if the other side is being so unreasonable when it comes to property division or support, where you know that you're going to do better in court and it's worth spending the money. Now, why would you choose to go to court instead of agreeing to arbitrate? I love arbitration, so I really can only think of two scenarios where I would tell a client, let's go to court instead of arbitrating. One is where a delay will be to the advantage of the client. The other is if I know that the assigned judge is one who is likely to rule favorably for my client. Outside of those situations, I tend to prefer arbitration.